The Firm, India's only show on corporate law, tax and audit matters.
A sprawling colonial bungalow in South Mumbai's Malabar Hill houses the state's highest-ranking judicial officer. Bombay High Court Chief Justice Mohit Shah has been its resident for 5 years. In that time, he presided over several important cases, ranging from complex commercial matters to issues that Mumbai holds dear, such as raising the height of railway platforms and clearing cartoonist Aseem Trivedi of sedition charges. Chief Justice Shah retired in September on turning 62. That he missed an elevation to the Supreme Court is a controversy he prefers not to talk about. The Hindustan Times claims the Supreme Court collegium found him and 2 other judges, Bhaskar Bhattacharya and Barin Ghosh, not suitable to hold the office of a Supreme Court judge. More recently, Supreme Court senior counsel Dushyant Dave wrote an open letter to the Chief Justice of India, criticizing Justice Shah's handling of certain cases. Dave opposed any possible elevation of Justice Shah. The mild-mannered judge won't comment on either story, so instead I spoke to him about judicial reform, the selection of judges, and whether the National Judicial Appointments Commission is better than the collegium system.
Since the NJAC issue is under challenge before the Supreme Court, I would not like to offer my comments. But let me start right from the cadre of civil judge junior division upwards, because our judicial system is concerned as much with the appointment of judges at the lowest rung as with the appointment of judges in the apex court. Like appointment of civil judge junior division, 3 years back when we tried to make appointment to about 100 posts of civil judge junior division, we hardly got 52 candidates who could qualify, who were found to be competent and suitable for the post. Then we realized that something has to be done about it. So at one of the conferences organized by the Bar Council of Maharashtra and Goa, I appealed to them to conduct training classes for lawyers aspiring for judgeship, with the result that this year the Bombay High Court could get as many as 224 judges for the post of civil judge junior division. So I think a positive role to be played by both the bench and the bar will help us in filling in those vacancies. Then next, going to the cadre of district judges. Earlier we had a system where lawyers practicing in the City Civil and Sessions Court in Mumbai and those practicing in the Metropolitan Magistrates Courts, they would be considered and they would be appointed as City Civil judges or Metropolitan judges. They were not transferable, so lawyers were ready to join as City Civil Court judges or as Metropolitan Court judges. Thereafter the Shetty Commission recommended, and the Supreme Court accepted that recommendation, that there should be a merger of the cadre of district judges and the City Civil Court judges, with the result that the judges of the City Civil Court also became transferable. So the lawyers in Mumbai practicing in the City Civil Court and the Metropolitan Magistrates Court stopped applying. So that important source of recruitment has dried up. The consequence is that the lawyers who were conversant with the complex litigation issues of Mumbai are now not available as judges. Therefore, the judges coming from other districts, of course, they are not as conversant with those complex issues. Of course, we are giving them training, but they need some more time. And after a few years, they get transferred after 3 years. So this is one issue which I want to emphasize, that in a vast country like India with so many diversities, it is not necessary to look for uniform solutions for all the states.
But what specific solutions would you recommend?
I would suggest that there should be a rethink on this question of merger of the cadre of City Civil Court judges and the district judges. That could be given a rethink. The other issue is that there are many lawyers who are very competent. They are ready to accept judgeship, but they do not want to face this competition of competitive examination and the fear of being rejected. Suppose a lawyer who has been practicing on the civil side for 20 years, 15 to 20 years, he may not be conversant with the criminal laws.
So what could be the solution to that, sir? You have to create some level playing field, so to speak, right? How would you exempt them from examination?
We can conduct their selection process
Differently?
only to test their suitability in civil laws. They may be appointed as civil judges, and they can handle civil work.
Okay. What about the senior judiciary, sir?
Well, as far as High Court is concerned, under the old system, it was the High Court Collegium which used to make the recommendations, and thereafter the Supreme Court Collegium would finally make recommendations which would be binding on the central government. But there also I feel that as far as recommendations made by the Bombay High Court Collegium are concerned, by and large they were accepted. There were a few cases where, because of some adverse IB report, the Supreme Court Collegium may not be inclined to clear those names. It so happened in one case that the Collegium returned some names on the ground that there was an adverse IB report. So I requested the then Law Minister to share some inputs in case we have an answer for those findings in the so-called findings in the IB report. We can clarify the position, and because the judicial officer was known to be a very honest and competent officer. Fortunately, the then Law Minister shared some inputs with me, and we sent a 4-page letter,
Response to it.
minutes of the Collegium, High Court Collegium, running into 4 pages, clarifying all issues, and that judicial officer came to be elevated as a High Court judge, as an additional judge, and then became a permanent judge. But when a similar situation had arisen earlier, the predecessor Law Minister did not share the inputs with me. Therefore, we lost a very good lawyer candidate. Let me just give you one illustration. Like it said about judge of the Delhi High Court, that when his name was recommended by the High Court Collegium, there was an adverse IB report against him that he is a boozer. And when some Supreme Court judge shared the information with the Chief Justice of the Delhi High Court, he pointed out that the man is a teetotaler, but because in his college days also he was a teetotaler, his friends used to tease him as a boozer, and that is how the report went, that he was a boozer. Now this fact, had it not been brought to the notice of the Chief Justice of the High Court, he would not have been able to clarify it.
Right.
So this is a very important issue, the role to be played by the Chief Justice of a High Court in this consultation process.
So let me ask you, the NJAC solution to the collegium system, which many judges and Chief Justices of High Courts and Supreme Courts have admitted is flawed, needs more transparency, etc. But the NJAC solution seems to have gone the other extreme. I'm not asking you to suggest what the Supreme Court will decide. I'm simply asking you, based on your 20 years in the judiciary, what system do you think is better suited for India in the current circumstances?
Let me not deal with the NJAC issue. I would just point out about the system which was prevailing before the NJAC amendment was made. Article 124, Clause 2 says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary. Now, consultation with such of the judges of the Supreme Court as the President may deem necessary. The 1993 Supreme Court judgment said that the consultation should be with the Chief Justice of India, the 4 senior most judges, and the judges from that High Court. The Supreme Court judges who have come from that High Court. About 10 years back, 10 years before that 1993 judgment, the policy was introduced that a Chief Justice of a High Court should be from another state. He should not be from the same state. The idea was that person carrying or possibility of person carrying local biases and prejudices should not become Chief Justice of that High Court. So now when a person goes out as Chief Justice of another High Court, and thereafter when he goes to the Supreme Court, do you think that the that the biases and prejudice will disappear on assuming that other office, because Justice A.K. Patnaik has gone on record as to what happened, why his elevation was delayed. I need not go into that, he has gone on record. So also Justice Bhaskar Bhattacharya has gone on record indicating what happened. So the judges from the same state can play a role which may sometimes become decisive.
So
Secondly, Article 124(2) also said that the President may consult such other judges of the High Courts. Now that 1993 judgment did not deal with this provision. Probably, there was no process of consultation with the judges of the High Courts from which the concerned judge or the Chief Justice was to be elevated to the Supreme Court. So I think that something required to be reconsidered on that issue.
If the NJAC system were to prevail, do you think that we would have better, more effective selection of judges to the senior judiciary?
It has to be tried out.
There are over 2 crore pending court cases across India, of which 29 lakh cases are pending in Maharashtra. That's less than the 41 lakh pending cases 5 years ago. Bombay High Court Chief Justice Mohit Shah says that during his term, the number of pending bounced check cases also declined from over 6 lakhs to 57,000.
Yes, of course, appointment of judges is one solution.
Right.
Appointment of more judges. But mere appointment of more judges is also not going to solve the problem. We have to realize that to deal with such a heavy backlog of cases, particularly civil cases, we'll have to go for ADR. And ADR has not quite succeeded in India because we call it alternative dispute resolution. Means the trial or the court battle is the main or the right solution, and the others are alternatives. Actually, I would like to call them appropriate dispute resolution mechanisms.
Mindset change, appropriate dispute resolution. You haven't yet spoken of case management, sir.
Yes, of course, that is also equally important.
I thought it was integral case, yeah.
Because people would not like to go for other appropriate dispute resolution if a defendant who doesn't want to pay any money to the plaintiff, although he owes the money to the plaintiff, will not like to go for any of these ADRs because he would rather wait and let the court process take 20 years. So the courts should exercise this discretion that where litigants are not ready to go for appropriate dispute resolution, their cases should be heard more expeditiously and given more priority, so that a dishonest litigant does not get the benefit of delaying court processes.
We've seen some efforts at putting in provisions for case management when it comes to the commercial courts bill, and yet when I talk to lawyers, they are skeptical of any of those case management provisions working because they simply feel that judges are overworked. They have 100 cases every day to deal with. How are they ever going to devote time to a particular case and finish it speedily when there are 99 other cases pending in the day? Every solution we talk about sort of seems to be part of this vicious cycle that takes us back to either the shortage in the number of judges or the shortage in the number of courts.
There is one problem which I think is not being addressed. 80% of the work is with 20% of the lawyers. So even when there are more judges, the lawyers would not be attending all the courts because they will say that they are busy in other courts. So it is high time that we encourage junior lawyers to come forward and argue cases. If this happens, then once this issue of 80% cases remaining with 20% lawyers is resolved, I think that will also be a significant step forward.
Is this problem ever going to get fixed, or in India, justice delayed is justice denied is going to be the refrain for tens of years from here on as well?
Let me clarify this issue. For instance, I have the statistics to tell you that in Maharashtra, out of about 29 and odd lakh, 29 lakh cases, and as many as 60% cases are less than 2 years old. Another 20% cases are between 2 and 5 years old. So 80% cases are less than 5 years old. So the people whose cases get decided early, they do not go and tell the rest of the world that their case got over in 2 years or 3 years. The remaining 20% cases, the litigants whose cases are not yet decided, they will, of course, they would be justified in making a grievance that their cases are, the courts are taking too long for deciding their cases. So this, we must also consider this, that there are a large number of cases which are being decided within reasonable time.
Okay, let me put the question to you this way then. If the government, whether it's this government or any other government, if the government decided to spend more money to setting up more courts, training more judges, and I grant that it would be a 5-10 year process, but if they did that, do you think that would be the biggest way to resolve this issue of pendency, and that without that, you know, all other measures are small measures, significant, but not making a big dent in the problem?
I would agree. For instance, let us say, take the courts of Metropolitan Magistrates in Mumbai. There is a pendency of about 4 lakh cases. We have more than 70 to 80 Metropolitan Magistrates in Mumbai alone. But we want to have more Metropolitan Magistrates in Mumbai, but there is no accommodation for them in places like Andheri or Dadar. We requested the state government to provide more accommodation. That is not forthcoming. And I believe in the 14th Finance Commission, a lot of provisions are now made for the infrastructure and other requirements. The difficulty with the 13th Finance Commission recommendations was that they provided for grants under various heads, such as morning and evening courts. Now the judges who are already overburdened with work during their regular court hours, if they are also asked to work in mornings and evenings, it was causing a lot of hardship to them. So we could not spend substantial funds from the grants available under the morning and evening courts. In fact, more than 250 crore or 300 crores lapsed.
Because of this?
Because of this.
So the other problem is that governments, whether they're state or central governments, are not speaking to the judiciary and understanding this.
The High Court should be given more financial autonomy also, not only the funds, but also the financial autonomy, so that wherever they consider appropriate, the funds can be spent expeditiously. At present, even when the central government provides grants, the grants are provided through the state government. And whenever any proposal is made, then by the High Court, then the state government would take time to process that proposal and deal it with it the same way as if the funds are coming from the state government, with the result that the process gets slowed down.
You have spoken in the past of how the Chief Justice of a High Court ought to play a far more enhanced administrative role as opposed to a judicial role in that sense, in terms of hearing cases, etc. Because then he can devote, or she can devote his or her time in actually managing court processes and ensuring that the court is working to its optimum level.
Somehow the expectations of the people within the system is that the Chief Justice, whether he is the Chief Justice of the Supreme Court or Chief Justice of the High Court, should do as much judicial work as the other judges are doing. So they should do full-time judicial work from 10:30 to 4:30 or 11 to 5. And I don't think in any other country the Chief Justice of a High Court or a Supreme Court is supposed to do as much judicial work as the other judges are doing. In almost all other countries, the Chief Justice of the courts at whatever level spends more time on administration than in judicial work.
Okay. I want to come talk to you about, and then part of the judicial reform process is also, the perception of judges post their judicial tenures, right? We've had a couple of controversies in the recent past, especially more recently when a Supreme Court Chief Justice was offered the position of governorship of a state, and he accepted it. And questions were raised, therefore, as to whether this is the best way to preserve the independence of the judiciary. Where do you stand in this debate?
I think it's for each individual to decide whether he would like to go for such an assignment or not. Speaking for myself, I have already made it clear that I don't believe in going for such an assignment after retirement.
Is that based on a principled position that you don't think that Chief Justices, judges, Supreme Court judges should not accept such positions?
I believe that there should be some cooling off period before accepting any such appointment, which does not involve any adjudicatory work or any legal work, like the Chairman Law Commission, for instance, is supposed to give reports on law reforms. So for such an office, of course, there need not be any cooling off period, but for offices which do not involve any such legal work, I think cooling off would be a good idea.
Since you speak so fondly of your 5 years in the Bombay High Court, what do you consider your unfinished agenda there?
Obviously, appointing more judges to make it full strength of 94 judges, having more infrastructure, and giving the judges little more space to deal with the backlog in their own imaginative way.
Okay.
What happens is that right now the judges are so overburdened that even when they want to make some experiments, they don't have any room to make those experiments. So I wish if with more judges available to the Bombay High Court, the judges can work more effectively.
Thank you for your time, Chief Justice Shah.
The Firm, India's only show on corporate law, tax and audit matters.